Siamo oggi al primo evento di approfondimento dell'anno 2021 organizzato da ICALI. Il tema che abbiamo scelto è quello della Brexit, perché la Brexit non pone soltanto problemi dal punto di vista politico interni al Regno Unito, ma soprattutto nei rapporti con l'Unione Europea. Non è un caso che gli unici 3 referendum che si sono tenuti nel Regno Unito hanno tutti riguardato il tema dei rapporti con l'Unione Europea. La Brexit pone problemi dal punto di vista economico, c'è una sorta di ritorno al passato, un'epoca in cui l'impero britannico imponeva gli standard e non si adeguava alle regole imposte e dettate da altri, dalle istituzioni europee. Ma la Brexit pone anche problemi sotto il profilo giuridico. Sono problemi complessi ai quali ICALI è particolarmente interessata, perché ICALI è un'associazione nazionale italiana composta da avvocati italiani che si occupano di questioni di diritto di famiglia internazionale, ma soprattutto ICALI ha una vocazione europea, una forte vocazione europea che nasce dalla sua storia, perché ICALI appunto ha origine dal network europeo LEPCA, Lawyer in Europe on Parental Child Abduction, quindi un progetto, un'iniziativa che ha come finalità non solo quella della formazione specialistica degli avvocati sui temi del diritto internazionale di famiglia, ma soprattutto quella di creare una rete di avvocati che tra loro abbiano rapporti stabili di collaborazione, di cooperazione, di scambio di esperienze, di lavoro concreto sui casi. E è questo quello che vogliamo fare oggi, questo scambio che è particolarmente importante laddove parliamo di una questione molto rilevante come quella dei rapporti tra le fonti multilivello. È per noi usuale avere a che fare con norme interne, il diritto internazionale privato, ma norme convenzionali. Le convenzioni internazionali, quelle che utilizziamo di più nel nostro lavoro, sono la Convenzione AIA del 1980, la Convenzione dell'AIA del 1996, ma soprattutto i regolamenti europei. I regolamenti europei, primo fra tutti il Bruxelles 2 bis. Sappiamo benissimo il ruolo fondamentale che questi regolamenti hanno avuto nel creare uno spazio giudiziario europeo, nel dare certezza del diritto e favorire quindi la libera circolazione all'interno dell'Unione Europea delle persone, delle relazioni familiari, che tra persone appartenenti a paesi diversi con diversa cittadinanza. Ora, quello che ci chiediamo è cosa di questo sistema anche di cooperazione giudiziaria tra le autorità giudiziarie, cosa accadrà. E di questo ci parleranno i nostri 2 ospiti, 2 avvocati di fama internazionale che hanno competenze e profilo internazionale. Thank you very much, Susan, and thank you, James. We are looking forward to hear from you the consequences of a Brexit in family law disputes and to understand better what rules must be applied now. Introduciamo subito i 2 relatori. Cedo la parola alla collega Grazia Cesaro, vicepresidente di ICALI, nonché presidente dell'Unione Nazionale Camere Minorili, che ha organizzato questo evento insieme ad ICALI. A te, Grazia.
Grazie Paola. Sì, Unione Nazionale Camere Minorili ha voluto fortemente patrocinare e organizzare questo evento con ICALI, perché è evidente che questo perché stiamo parlando appunto di famiglie, stiamo parlando di molti minori che sono coinvolti. Sappiamo che tra il Regno Unito e l'Italia le famiglie miste sono tantissime. E allora quando parliamo appunto di diritto di famiglia internazionale, la domanda è che cosa ne sarà adesso di tutte le norme che noi abbiamo finora applicato, grazie appunto alla cooperazione giudiziaria rafforzata che era garantita appunto dalla presenza dei regolamenti europei. Allora, il Regno Unito oramai dopo 47 anni fa era entrato nella comunità economica europea e oggi, come anticipava appunto Paola, dal 1° gennaio oramai è fuori. Sicuramente lo sappiamo tutti, non è una hard Brexit, quindi non è stato un no deal, ci sono stati molti accordi, ci sono stati degli accordi che hanno però riguardato delle controversie che non ci riguardano. Il diritto di famiglia in questo momento si trova a essere un po' appunto sprovvisto di regole certe. Ed allora quello che noi chiederemo ai nostri relatori è appunto un aiuto per capire quali di queste le regole, dove potremo andare a trovare queste regole. Sicuramente dovremo rispolverare le nostre convenzioni, le convenzioni che vengono date dalla conferenza internazionale dell'AIA e sicuramente forse sarà anche il caso di andare a comprendere se ci possono essere d'aiuto qualche accordo bilaterale, o comunque è evidente che bisognerà comunque in qualche modo capire quali sono a questo punto gli strumenti che noi potremmo utilizzare. È evidente che questo interessa anche noi come avvocati di famiglie e minori, è per questo che proprio come primo evento dell'anno l'abbiamo voluto proporre, perché non possiamo dimenticare che senza regole certe c'è tutto nel diritto di famiglia internazionale, c'è tutto il problema della forum shopping, quindi c'è tutto il problema di un aumento del conflitto a livello giudiziario, e quindi ovviamente c'è tutto un problema poi di aumento del conflitto anche all'interno delle situazioni familiari, e quindi di mancanza di sicurezza per quelle che devono essere appunto le situazioni appunto familiari, che riguardano soprattutto i minori che vengono appunto coinvolti in tutte queste vicende. Abbiamo chiesto a due, direi, posso dire sicuramente colleghi, ma anche esperti del settore, sono i colleghi Susan Todd e James Thompson della Copson, scusate, sono due colleghi che sono dello studio di un'importante law firm di Londra, lo studio Weavers. In particolare Susan Todd è responsabile del Divorce and Family Team e James Thompson è partner e membro del team. È uno studio che si occupa normalmente di controversie internazionali, ha seguito molti casi di diritto internazionale appunto tra il Regno Unito e l'Italia, e quindi ha una grandissima esperienza rispetto a proprio questo. In particolare appunto Susan parla anche l'italiano, ma non, purtroppo ha preferito in questa presentazione i nostri relatori ci aiuteranno, parleranno in inglese, ma abbiamo chiesto loro, hanno fatto lo sforzo di preparare delle slide in italiano. Quindi complessità della materia sarà comunque agevolata dalla possibilità di avere anche delle slide, una presentazione fatta in italiano, e anche di questo appunto li ringraziamo ulteriormente. Allora, cari, sono anche diciamo degli amici per me, per tutti noi avvocati che ci occupiamo di diritto di famiglia nelle controversie con il Regno Unito. Sappiamo che loro sono insomma dei nominativi certi ed esperti in questa materia. Allora, cari Susan and James, thank you again to be with us. The question is simple. What's up now? Thanks a lot, Susan and James. You have the floor now.
Grazie mille. Buongiorno a tutti. È veramente un piacere per James e io essere qui con voi oggi, ma oggi vado a parlare in inglese. Allora, so it's been a long road for us here in London in terms of where we would get to in terms of family law post-Brexit. James and I today are going to deal with what we know, what we don't know, and to give you some points to remember. But the most important thing to remember is, if in doubt, take local advice. So as you can see from the slide, there are going to be some fundamental changes in how we in the UK interact with all of the other European countries from a family law perspective going forwards. The slide gives you some of those examples: children, divorce, maintenance, and also importantly, recognition and enforcement. So where are we now? We are, or were, in a phase of transition. So we theoretically left the European Union last January. We then had what was called the withdrawal agreement, which for family lawyers and for everybody else we called a divorce agreement. We then had a period of transition, so nothing changed on the ground for us before the 31st of December 2020, when at 11 p.m. for us and at midnight for you in Italy, we finally left the European Union. For some of us, that is very sad, and for others, they are happy. I personally fall into the sad camp. So there was lots of discussion about what the shape of a deal would be, and would we have a deal or would we not have a deal? And as you will know, the UK finally entered into an agreement just before Christmas. So what do we know now? What we definitely know is that family law is not a priority and has not received any proper attention whatsoever in the context of all of these discussions. The agreement that was made in late December has no great impact on what we thought would happen. So we do have UK government and European guidance on cross-border family disputes. We have our new European Union, and funny from a family law perspective, it's called a Future Relationship Act 2020. So maybe it's a bit like a prenuptial agreement or a postnuptial agreement. But what we know for certain is any proceedings that were issued before the 31st of December 2020 will be treated under the old rules, and that everything going forwards will be treated under a different set of rules. So for James and for I in December, we had lots of clients trying to work out whether or not they should be starting either divorce, finance or children proceedings before the changes in the rules. So how is it going to work going forwards? So James and I are going backwards in time. Most of the arrangements will be through existing international treaties, some of which we have set out on the slide for you today. The Hague Conventions are going to be vitally important. Divorce recognition, continued child abduction, parental responsibility, and maintenance. There have also been changes to our domestic legislation. So in terms of the divorce jurisdiction, we're going back to the way it was when I qualified as a lawyer in 1999. So looking first at the children framework. So to be clear, any cases that you have that started before the 31st of December 2020 will continue under the current European rules. Unfortunately for us, Brussels 2 bis will continue without us. That legislation had lots of really important new developments in terms of improving efficiency and cooperation between the member states. So we will be going back to rely on our domestic law. So the Hague Convention, Conference Conventions, 1996 for children, 1980 for child abduction, that a lot of you will be familiar with. Jurisdiction going forwards stays the same. So there is no change, it is still habitual residence. But there are other changes. It will not be possible to agree the future jurisdiction. There will be different tests of transfer of jurisdiction in children proceedings. At the minute, there is the ability for the court to retain jurisdiction for 3 months after, for example, a child moving to Italy. That will not be possible. And there will be no automatic enforcement anymore, and that mechanism will need to be looked at. Also, from a children point of view, some of you may have come across a piece of English law called Schedule 1 of the Children Act. For those of you who've heard about it before, it's a piece of law that deals with rights for unmarried parents who have children. It looks to provide house for the child and also maintenance for the child and also potentially for the mother. Where James and I come across this quite a lot is if you have an Italian footballer, for example, who comes to play for Manchester United, Arsenal, whichever team it happens to be, has a relationship with someone over here and has a child, and then suddenly they find out that there are all of these extra obligations. Please note that going forwards, only if we join Lugano, which we have not, can you have a written agreement for child maintenance. This wasn't previously allowed. So that law is going to stay the same. Turning now to divorce. So the big news flash, and the reason why there is a picture of a bicycle, is because all of you will know that within the European Union, there is a race to start divorce proceedings. First in time, provided that everything is done properly, is the country that wins. We no longer have that anymore. So there will be no first in time races from an English perspective. Now, with some countries, it will still be very, very important to be the country that starts the divorce proceedings first. But there will be no mandatory stay going forwards as we have at the minute. If proceedings are started in Italy or in England, then the Italian court must, at the minute, press pause on their divorce proceedings. And the other difference to note going forwards is the basis on which a divorce can be started. So until now, we could only have a divorce in England based on one person's sole domicile. And all of you will know that domicile from an English perspective is different from the Italian concept of domicile. So for you, domiciliato is like our habitual residence. Going forward, it will be possible for England to have a divorce petition based only on sole domicile. What we don't know at the minute is whether or not other European countries are going to respect this going forwards. So no race and no automatic stay going forwards. So what's going to happen instead? So we're going back to the old Latin phrase of forum non conveniens, which means one country has to stop if another country is more important. So these are the arguments that we used to have when I qualified as a family lawyer 20 years ago, and which James had for the first part of his career. So now an English court will have the discretion to grant a stay of a divorce proceedings if there is a country that appears more appropriate. And how do we look at that? So the court will look at a lot of factors as to which country has the closest connection. Where you pay tax, where your medical treatment is, where do you go to church, which gym do you belong to? And I've had in an Italian case, which is obviously very important, where your Vespa is parked. But on a more serious note, there are lots of unanswered questions at the minute. What if we file in England first and you file in Italy second, but England says we are the country with the closest connection? Will Italy ignore us because you were first in time in the European rules? What if we file in England first and you file in Italy second, and England decides that Italy has the closest connection? Will you accept it because you're technically second in time? Or what happens if Italy is first and England is second, but we in England decide that we are the closest connection? Will the Italian courts stop those proceedings? We have lots of unanswered questions at the minute. What is also important, because obviously with the cross-border divorces, it's important that the divorces are recognised in the different countries. Article 21 of Brussels 2 bis will not apply going forwards. So again, we are going backwards in time, back to the 1970 Hague Convention in terms of recognition of divorce and legal separations. The challenge at the minute is that there are only 12 European countries who are party to this convention. Thankfully, for the purposes of today, Italy is one of those countries. So hopefully there will not be a lot of difficulties with this. The challenge for us with the other European countries who are not signatories, for example, some of you might hear my Irish accent. Ireland is not a signatory to the 1970 convention. So what happens if an Irish couple living in England get divorced here, but then go back to Ireland? Will the Irish courts recognise their divorce? We're going to have to be really careful on a case-by-case basis to make sure that advice is taken in each of these countries to make sure that it's going to work. Thank you very much. Grazie mille per aver ascoltato. E adesso passo la parola a James.
Suzanne, thank you very much for that run through of the situation as it is evolving so far. I would like to deal with a few other issues in connection with our departure from the European Union, sad though it may be for many people. And I'd like, first of all, to deal with the question of maintenance and enforcement of maintenance obligations. Well, to start off with, we need to know what, in fact, maintenance is. And fortunately, there is an old case from 1997 called Van den Boogaard and Laumann, which stipulates that maintenance is whatever is required to meet needs. And you might wonder what actually that means. Well, it's been expanded to mean that it has to be an award which is designed to provide for a party to meet his or her day-to-day needs, and is not solely for the purpose of dividing up property arising out of a matrimonial relationship. Now, how do we have enforcement between our countries? Because now we have left the European Union, the United Kingdom is no longer a signatory to the European Union maintenance regulation. So what will be in its place? Fortunately, as Suzanne mentioned, we and Italy are signatories to the 2007 Hague Convention. We're going to have problems with some countries, notably Germany, France, Spain, who are not signatories to that convention. And the other option that we would like to have, but we don't have as yet, is the Lugano Convention, because we are not signatories to the Lugano Convention at the moment, because we were only signatories as a European Union member state. We have applied to join the Lugano Convention in its own right, but that requires the consent of the European Union. And I think that because the Lugano Convention covers not just matrimonial matters, but particularly issues which assist small businesses, the European Union has sadly dragged its feet over it. And in any event, there's still going to be a further gap, because if the European Union does give consent, then there is a 2-month lead-in time after papers are submitted, and then we have to have our own UK legislation. Now let's have a look at the next slide and the Hague Convention. Well, the Hague Convention of 2007 is intended to provide a simple, quick and efficient system for the enforcement of family maintenance between the contracting states. It came into force, as far as we were concerned, on the 1st of January 2021. It was negotiated at the same time as the maintenance regulation and was intended to have worldwide effect. And whilst we were members of the European Union, we were of course subject to the maintenance regulation, which took precedence. Now, its purpose is intended to ensure the effective recovery of child support and other forms of maintenance. And any contracting state can actually extend the application of the convention to all maintenance obligations arising out of a family relationship. But there are a few things that we need to be aware of. First of all, unlike the maintenance regulation, there are absolutely no rules as to jurisdiction. In fact, the only grounds for jurisdiction that is mentioned within the convention is in connection with variation, which is similar to the maintenance regulation. So basically, where the creditor remains habitually resident in the place of the original order, that's where jurisdiction shall lie. There's no rules also about lis pendens. And fortunately for all of us, the grounds for recognition and enforcement are similar to the maintenance regulation. But there are also, luckily enough for some of us, more grounds for arguing non-recognition. So moving on to the next slide, I mentioned that the Hague Convention doesn't cover jurisdiction. So as far as England is concerned, we go back to domestic law. In divorce cases, maintenance is based on the divorce application, the petition for divorce, and is pursued further with what we call a Form A. Within a marriage, you can also have other means of obtaining maintenance. And this is under section 27 of what we call the Matrimonial Causes Act, which is the ground of failure to maintain. Now, on that ground, the basis for jurisdiction is either a party's domicile, the applicant's habitual residence for 1 year, or where the respondent is actually resident. Now, Suzanne mentioned Schedule 1 proceedings. This is, as you remember, financial provision for children. And this has a wider basis of jurisdiction. So basically, what you have to have is simply the habitual residence or domicile at the date for the application of either the parent or a child, or guardian if we have a guardian in place. There is one complication that we sometimes face in cases between Italy and England, because in England we have this weird piece of legislation, as some might think, that even after you've had a divorce and a financial order made in a foreign country, you can actually apply in England for further financial provision under what's called Part 3. Now, the basis for jurisdiction on that is the domicile or 12 months habitual residence at the time of either the foreign divorce or the application. And there are some more restrictive provisions if you are looking to gain an interest in the family home, but those are very, very small. Basically, you're looking at the domicile, 12 months habitual residence, or the family home being in this country, in England. With maintenance agreements, you're looking at domicile or residence of both parties. It's not habitual residence. Pension sharing, you can only have pension sharing where there is another connection with this English jurisdiction. And then we come on to the position between England and the other parts of the United Kingdom, because England has a completely separate law from Northern Ireland and from Scotland. At the moment, we don't actually know what the answer is. And so there's going to be a test case on that, I'm sure, sometime soon. Now, moving on to recognition and enforcement. What you're going to see is that if the jurisdiction was based on the habitual residence of the respondent, the creditor, or the child at the time that the proceedings were instituted, then basically what the Hague Convention says is that that decision should normally be recognized and enforced. There are a few exceptions to that, and they include any agreement as jurisdiction that the parties have in fact entered into. Equally, if the decision was made by the authority exercising jurisdiction on the matter of personal status, so divorce, or parental responsibility, the view of our Ministry of Justice is that it doesn't also exclude jurisdiction based on sole domicile. And as Suzanne mentioned, sole domicile is a different concept under English law. It's not where you live, it's not your nationality. It's something a little bit more complicated by that. And that's something that we are thinking is going to have to be decided by case law. Variation proceedings. Well, if you're looking at proceedings to vary a maintenance decision or make a new decision, well, that actually can't be brought by the debtor in any other contracting state, so long as the maintenance creditor remains habitually resident in the state where the jurisdiction was made. This, of course, is subject to any written agreement, or perhaps the creditor deciding that they're going to submit to the jurisdiction of the court without objecting to it. Now, obviously, as far as recognition is concerned, a decision must only be recognised if it has effect in the state of origin, and of course is only enforceable if it's enforceable in the state of origin. Now, I mentioned earlier that there can be grounds for a refusal of recognition and enforcement. And those grounds are at the discretion of the court, and they're covered at Article 2 of the Convention, Article 22 of the Convention. And they are that the decision is manifestly incompatible with public policy, or the decision was obtained by fraud in connection with the procedural requirements. Equally, if the decision is incompatible with a decision rendered between the same parties and having the same purpose in another state, then that might be refused recognition and enforcement. And plainly, if a respondent to the proceedings was neither involved in those proceedings, either personally or not represented in the proceedings, then that might also be a ground for a refusal of recognition and enforcement. Now, how do we go about this? In this next slide, there is a role to play for central authorities. Each country has a central authority to process enforcement applications. And in England, it is the Lord Chancellor who is the central authority. And what happens is that upon registration, the decision is enforceable as though it was made by the Court of Registration. And under the rules, the enforcement must provide in the state of enforcement at least the same range of enforcement methods as are available in domestic cases. Here in England, we actually have a fast-track procedure so that enforcement can be rendered possible rather more swiftly than in perhaps other enforcement cases. One good thing for some of your clients is that where you have applications in respect of children, then there is legal assistance available for free from the state in most circumstances. Now, I mentioned a little while ago that there might be two options available to us, not just the 2007 Hague Convention, but also the one that we'd like to be a member of, which is the Lugano Convention. As I said, it was a convention that we were a member of as a result of our membership of the European Union. It is a much more wide convention than the Hague Convention because it covers all civil and commercial matters. So it's not just a maintenance convention. However, it doesn't apply to things like marital status or to matrimonial property rights. So we're looking here at maintenance, and maintenance is just as in Van den Boogaard needs, and it's fairly strictly interpreted. Now, there is a UK case that I was involved with at the enforcement stage, which is called AAZ and BBZ. It's Akhmedova v. Akhmedov, as it has since become known. And in that case, the wife was awarded £453.5 million as her divorce settlement, together with her own assets of about £10 million. Now, we knew when we took over the case that there were going to be problems about enforcement, and so we made our application based on what was available to us under the Lugano Convention against Swiss-based assets. And we were helped because the English court had actually said, well, what part of this award of £453.5 million is maintenance? And the English court said, well, £225 million of that is for her needs. And those needs include her providing a property for herself in England, a property for herself in a foreign country, and spousal maintenance and professional costs, with the spousal maintenance being bought off as a one-off payment. Under Lugano, the jurisdiction is generally based on the domicile of the respondent. So persons domiciled in a state shall, whatever their nationality, ordinarily be sued in the courts of that state. Domicile, as Suzanne mentioned, has its own meaning wherever you are. And in England, there's a two-limb test for domicile under the Lugano Convention. First of all, the person has to be resident in the United Kingdom. And secondly, the nature and circumstances of the residence should include a substantial connection with the UK. Here we've also added that 3 months of residence gives rise to a presumption that a party is domiciled. Now, there are some exceptions to the general rules about suing the respondent where the respondent is domiciled. So first of all, as you might expect, if the respondent enters an appearance, gets involved in the proceedings, then the proceedings can continue with enforcement. If, as I said, the parties have agreed to have the proceedings enforced in a certain state, and that's obviously needed to be evidenced in writing. And that does include any child maintenance agreements, which, as Suzanne mentioned, is prohibited under the maintenance regulation. So this creates exclusive jurisdiction unless the parties have agreed something else. And in maintenance proceedings, the proceedings can be enforced in the courts of the maintenance creditor or in a place where there are related claims in respect of status or parental responsibility, unless jurisdiction for those are ancillary matters based on sole nationality. So the question that arises, of course, is, well, what is an ancillary matter? Now, an ancillary matter could be domicile. Well, is domicile, for example, the same as sole nationality? The English Ministry of Justice says that it thinks that that's different from sole domicile, but we don't know whether that is something which is going to be considered different for the Lugano Convention. Now, with Lugano, we do, unlike with what Suzanne was talking about with divorce proceedings, we do actually have a first-in-time principle applying. So her slide with the bicycles is actually rather important. Moving on now to the next slide, which deals with recognition and enforcement. Now, unlike the Hague Convention, there are actually fewer grounds to be able to say that a decision shouldn't be recognised. And they are public policy, a party not appearing in the proceedings, or raise judicata. A failure to comply with the rules of exclusive jurisdiction is also a ground for non-recognition, and under Lugano there is a strict requirement that there can be no review as to the substance of the decision. Now, enforcement requires an application by the interested party for the original order to be declared enforceable in the requested state, and there is a particular document which is called Annex 2, which must be used to enforce, and it does require translation, obviously, into the language of the state in which enforcement is to take place. Now, moving on to capital. And capital here, I'm talking about anything other than needs, and pensions. Well, the result of us leaving the European Union is that, sadly, cross-border enforcement is going to be difficult. And it will depend very much upon where the asset is situated and the view taken by the local court as to what should happen. With pension sharing, there is now a position in which, where there's no other connection, a pension sharing order can't actually be enforced. Fortunately, in England, if you were to have a pension sharing order against an English pension made by, for example, an Italian court, although it sounds pretty unlikely they'd make one, but if you have the jurisdiction under Part 3, you can still proceed under Part 3, which was, of course, habitual residence for 1 year and domicile, or one of the two. So what do we do about choice of court agreements? So on this next slide, we're going to be looking at the position as it is now, because under the maintenance regulation, choice of court clauses were something which we were bound by. But since leaving the European Union, the position has changed. Now, what we say is that anything which was signed and executed before the end of December last year is something which would be enforceable at any time in the future. Now, what we don't know is whether a European Union state, such as Italy, would recognise a choice of court agreement in favour of England and Wales if it was executed before the end of December 2020, even if there was an attempt to enforce it afterwards. Now, the position there is going to be something which will be subject to debate in your courts at some time in the future. And this has an important impact because of things like prenuptial agreements, because the choice of court agreements are not covered at all by our withdrawal agreement, by the Brexit position. And what we have said in the United Kingdom is that jurisdiction agreements which were made before the day that we finally left the European Union, so last December, will in fact apply on the basis of the European Union maintenance regulation rules. But again, we're just not clear how you in Italy will be looking at such agreements. And I think this is taking us back to one thing which Suzanne was keen to say to you, which is that in these sorts of situations, it's absolutely vital to get local advice. So a few points to consider. Well, first of all, the European Union Court of Justice jurisprudence is still going to be important for us all for maintenance cases going into the future. With, sadly, domestic abuse, domestic violence, the position is that every civil protection order is not going to be automatically recognised across the European Union. Dealing with other smaller points such as service, the Hague Service Convention. Well, you can serve via central authorities and you can serve papers direct, unless it's illegal, such as places like Switzerland, where it is in fact illegal to serve personally directly. So if you're thinking about the means by which you are going to be serving papers, I think, again, back to what Suzanne was keen to emphasize, you really must get local advice. Now, taking evidence, of course, is another matter which needs to be thought about. Well, unfortunately, as far as we and the European Union states were concerned, the rules on taking evidence for cross-border cases came to an end on the 31st December. So we're going back to another Hague Convention, which is that of 1970, which deals with the taking of evidence in cross-border cases. Again, the important thing is to get local advice. So where does this take us to, with just a few points to make sure that we identify between ourselves? As Suzanne and I have said time and again throughout this discussion, it is absolutely vital that if you are having to think about any proceedings of any nature to do with family law, which has a cross-border element, then you really, really must get local advice early. And I think that the other thing that is going to happen is that we're all going to be working together quite a lot more, and I very much welcome that from this moment onwards, because I think that there's going to be quite a number of tough issues that are not yet covered by the rules, by case law, that we're going to have to work through together. And I'm sorry to say, but there are probably going to have to be some test cases in which the rules are going to be honed down so that, unfortunately, some of our clients are going to face the position where they are going to be the test cases. And that's not great, but sadly, things change. It's called progress for some, but we are not in that very nice, comfortable position that we were all in when the United Kingdom was part of the European Union, where for many years between us, we all knew exactly where we stood. So there's going to be a good amount of time for us to reflect, for us to work through together what the future holds. And let's just look and see where it gets us. So I'm going to hand back to Paola and Grazia, but I'd like to say finally a very, very big thank you for giving Suzanne and me the opportunity of giving you a little bit of the position from the English perspective as far as the departure that we have had from the European Union with Brexit, a word which we all hope will leave the English language as soon as possible. Thank you.
James and Susan. You were very, very clear, but clear about the big problem that arises now for all of us. And the final conclusion of James is the truth. No, we have the necessity to ask for an advice before to take any kind of decision with our client. A question that I wanted to ask you: what will happen about child abduction proceeding, in consideration of the fact that we have the convention, the Hague Convention, but not more the Brussels 2 bis regulation, with in particular Article 11 about the overruling proceeding, and a lot of rules that makes possible to overcome problem between member states, problem within member states of the EU. What's happening in the future?
Fortunately, the Hague Conventions on child abduction remain in place as far as we are concerned, and therefore any child abduction proceedings will in fact be able to take place very much as before, even though we have lost some of the more detailed rules that we had when we were members of the European Union. But I don't think there's going to be any real change, fortunately, as between our two states.
Thanks a lot. I have a question regarding our client. In your opinion, what is the impact for our client of these very important changes?
So I think one impact that's going to make a difference is in terms of the choice of where the divorce takes place. Okay. So under the previous rules, it was very clear cut. If you filed first in England or you filed first in Italy, provided everything had been done, that was the end of the discussion. Whereas now a client could find themselves with proceedings in Italy and proceedings in England. From an English perspective, what we would have to do is produce statements from both parties, which are expensive, which go into all of the detail and background of the relationship, the family, things that people maybe do not want to be discussing at an early stage if you're trying to keep everything calm. You've got the legal costs associated with the extra bit in the procedure. You've also then effectively got a hearing. So each party would have to give evidence about why they think that England or Italy is the right jurisdiction for their divorce to take place. So you've got the timing issue, the cost issue, and the stress issue for everybody as well, which doesn't have a financial, you can't put a figure to it. And then once you've decided which country is the right country, so it could take 6 months, 9 months to sort that out. And only then can you start looking at, okay, I'm going to get divorced in England, this is what will happen. I'm going to get divorced in Italy, this is what might happen. So the impact on the family from a cost point of view and from a stress point of view is potentially huge. In the cases that James would have done more than I would have done, the rules changed quite quickly after I qualified, and I have done some non-European forum cases, but it can have a huge impact for lots of different reasons.
I agree. I think that the difficulties that we are all going to face is, first of all, how long it's going to take, as Suzanne said, and secondly, how much it's going to cost our clients just dealing with an issue as to where a divorce should take place, because in many cases there isn't actually a disagreement about whether there should be a divorce or not. Fortunately, whilst those proceedings are ongoing, it is possible to secure orders for things like interim maintenance. So it's not as though everything is completely on hold. However, it does mean that things are going to be on hold as far as the divorce is concerned, as far as any financial order, final financial order is concerned. And so that's going to have a real impact upon clients. One thing I should mention is that in England, the UK Parliament has passed a law which says that you can have a divorce without fault.
Yes.
And we are hoping that law will become something which will be available to everyone to use from the autumn of this year. But I think that with everything else that our government is facing, it's probably not exactly going to be high up on the list of things they want to deal with. So it might be a bit later than that.
Grazie davvero. Ma io non so, Paola, se sei d'accordo, credo che dovremmo forse pensare già a un aggiornamento, magari tra 6 mesi di questo incontro. Oramai siamo in chiusura, però potrebbe essere utile anche salutarci oggi pensando a un appuntamento futuro tra un po' di tempo, così ci racconteranno i nostri ospiti che cosa poi è successo, quali sono le principali complessità. Abbiamo visto la litispendenza, il riconoscimento, forse è importante comunque cominciare a pensare che oltre a oggi a questo aggiornamento dovremo organizzarne anche altri.
Sicuramente l'incontro di oggi, diciamo, ci stimola a approfondire anche altre norme che ci sono state oggi evidenziate, sottolineate, che forse non conosciamo abbastanza. Cioè abbiamo scoperto quanto ancora abbiamo da studiare, da approfondire, specie se dobbiamo avere appunto un procedimento che riguarda il Regno Unito. E sicuramente avremo altre occasioni in cui invitare Susan e James, che sono stati così disponibili, così veramente per la disponibilità per la quale li ringraziamo davvero moltissimo. Se non ci sono altre questioni,
abbiamo finito il tempo.
Abbiamo finito il tempo e salutiamo tutti e alla prossima occasione di aggiornamento e di formazione di ICALI. A presto.
Grazie, see you again, Susan and James.
Ciao.
Ciao,
Ciao.
grazie davvero, grazie. Ciao, grazie.